The year is 2026. For centuries, the British monarchy has survived through a philosophy of never complain, never explain. But as the morning mist clings to the ancient stone walls of Windsor Castle, that era of silence has come to a violent end. We are no longer talking about tabloid rumors or he said, she said interviews. We are witnessing the total legal dissolution of the Sussex brand. Behind the scenes, a coordinated international legal offensive has been launched, one that spans from the High Court in London to the Superior Court of Santa Barbara. This is the story of the Great Decoupling. It is a war fought over 72-acre estates, multi-million-dollar alimony demands, and the ultimate prize, the future of two children, Archie and Lilibet. This is the breakdown of the most significant legal battle in the history of the House of Windsor. It began at precisely 5 seconds into the 2026 legal filing that shook the establishment. Meghan Markle, the Duchess of Sussex, initiated a claim that many saw as a final attempt to reclaim the sovereign influence she lost when the couple moved to California. The target? Wrenbrook Hill. Wrenbrook Hill is not merely a house, it is a 72-acre sprawling estate located in the heart of the Cotswolds, valued for its extreme privacy and historical proximity to royal land. Meghan's lead counsel, the formidable Cher Tilden, filed for full, independent ownership of the property. The move was a strategic masterstroke designed to give the Sussexes a permanent sovereign foothold in the United Kingdom, one that was independent of the Crown Estate's bureaucratic oversight. Tilden's argument was built on a daring legal theory. She claimed that Wrenbrook Hill was orally committed to Prince Harry and his family by the late Queen Elizabeth II herself. In the world of high-stakes real estate, an oral trust is notoriously difficult to prove, but Tilden argued that the Queen's intent was clear: to ensure her grandson had a home that could never be taken away by future monarchs. But the palace was ready. The response from Buckingham Palace was not a polite denial, it was a legal execution. They unequivocally rejected the claim, stating that no formal commitment had ever been made. More importantly, the palace legal team argued a fundamental principle of English law. Verbal assurances, even from the sovereign, are nullified the moment the intended recipients cease to fulfill the duties associated with the gift. The palace viewed the claim as a deliberate provocation, an attempt to test the resolve of King Charles III. As the property battle raged, the conflict moved into the realm of cold, hard currency. The public was stunned when Meghan filed for a 50-50 split of all marital assets, but it was the monthly figure that dominated the headlines: $215,000 per month in alimony. To the average citizen, this figure sounds astronomical, but to Meghan's legal team, it was a necessity. They argued that the global scale of the Sussex brand required a level of security, staff, and lifestyle maintenance that was commensurate with the grandchildren of the king. They claimed that the royal family had a moral and financial obligation to maintain the dignity of the Duchess, even in a post-royal world. However, the royal family's legal defense, led by the analytical Miles Armitage, had been preparing for this moment for years. Armitage presented what insiders call the Armitage dossier. Inside was a document that many believed would never see the light of day, a waiver signed by Meghan Markle during the initial Megxit negotiations in 2020. In this waiver, Meghan allegedly relinquished future claims to royal subsidies in exchange for the right to pursue private commercial ventures. Armitage argued that the $215,000 alimony demand was not just a request for support, it was a direct violation of a signed contract. The dossier painted a picture of a duchess who wanted the freedom of the private sector while still clinging to the bankroll of the public institution. While the money and the mansions made the front pages, a far more emotional battle was being fought in the California Superior Court. Meghan sought to reduce Prince Harry's child support, while simultaneously gaining full control over Archie and Lilibet's digital image rights. In the 21st century, image rights are a form of currency. To control the images of a royal child is to control a billion-dollar brand.
Meghan's team argued that as a biological mother living under U.S. jurisdiction, she should have the sole right to decide how her children are presented to the world. To bolster her case, Meghan filed a sealed declaration. This was a legal nuclear option. In the declaration, she accused Prince Harry of emotional volatility and alcohol dependency. These were not just personal insults, they were targeted legal strikes meant to disqualify Harry as a primary guardian. Meghan's team then appealed for a jurisdictional review. They argued that the UK's royal guardianship protocols, which historically give the monarch custodial oversight of royal grandchildren, could not and should not supersede a biological mother's rights under US federal law. It was a direct challenge to the very foundation of the Crown's authority over the bloodline.
The turning point in the court's opinion came from an unlikely source, a discovery made by the royal household's internal security team. They uncovered a brand deck titled Project Emancipation. This deck, consisting of over 100 pages of marketing strategy, revealed a plan to monetize the Sussex name globally while strategically excluding the children from the protective bubble of the monarchy. Project Emancipation detailed how the children's likenesses would be used in fashion, media, and digital ventures, essentially treating the heirs to the Sussex name as assets of a private corporate entity. This revelation provoked a response that was unprecedented in modern history. Princess Catherine, the Princess of Wales, stepped out of her traditional role to make a public statement. Her words were sharp, clear, and final. Children are not branding tools. They are not passports to power. They deserve privacy, protection, and peace. Catherine's statement wasn't just a moral plea, it was a signal that the royal family was prepared to use every legal tool in their arsenal to protect the children from commercialization. The Windsor firewall was about to be activated. The Windsor firewall was more than a legal defense, it was a total institutional shutdown. The royal household began a systematic process of erasing Meghan Markle's digital, financial, and symbolic footprint. First, a supplemental legal directive was drafted to permanently bar Meghan from using the Windsor name in any commercial, philanthropic, or political capacity. This wasn't just about a title, it was about the brand. Without the Windsor name, the Sussex brand lost its historical weight. Next came the financial review. A full audit of all jointly held assets led to the discovery of irregularities within the Archewell Foundation. These findings were so significant that they led to the foundation's legal dissolution. The joint Instagram handle @ArchieLilibet, which had been a centerpiece of their branding strategy, was suspended by court order. The palace then introduced a new dual consent clause. It stated that no commercial use of the children's names or likenesses would be permitted without the simultaneous consent of both the Crown and Prince Harry. This move effectively neutralized any attempt to monetize the children's royal status. The climax of the battle occurred in a moment of historic judicial cooperation. Both the High Court of London and the Santa Barbara Superior Court delivered their rulings on the same day in a coordinated effort to end the uncertainty. The courts effectively ended Meghan Markle's legal influence over her children. The ruling was devastating for the Sussex camp. Joint institutional custody awarded to Prince Harry and the Crown. Primary guardianship. Princess Catherine was appointed as the day-to-day guardian for the children's royal and educational interests. Liaison for external affairs. Duchess Sophie was tasked with managing the children's international engagements. The California court further ruled that Meghan's property entitlement claims were inadmissible, siding with the UK Privy Council assessment. Meghan's parental access was significantly reduced to supervised visitation, ensuring that the children remained under the institutional protection of the monarchy. The fallout was swift and total.
As the court rulings were finalized, the commercial world began to distance itself from the Duchess. Her multi-million-dollar deals with Netflix and Spotify were canceled. Fashion endorsements were terminated. The Sussex brand, once seen as a modernizing force for the monarchy, had been legally dismantled. Meghan Markle, once one of the most visible women in the world, went silent. Her social media accounts were deactivated, and the digital footprint of the Project Emancipation was scrubbed from the internet. The Windsor firewall had worked. In the end, it was Princess Anne who delivered the closing statement of this saga. Standing before the press with the weight of the institution behind her, she spoke a truth that echoed through the centuries. The matter has closed. The children are safe. The future is guarded by principle, not power. The legal battle of 2026 proved that the British monarchy is more than just a family. It is a system designed to protect its heirs and its legacy at any cost. For Meghan Markle, the attempt to challenge that system ended in a total decoupling. For Archie and Lilibet, a new chapter began, one protected by the very Windsor firewall their parents had tried to dismantle. The war for the Sussex legacy is over. The crown remains.